So this is going to be case number 25S00791FY. People of the state of Michigan versus Timothy Dansby. Sir, what's your name? All right, Mr. Dansby. Good afternoon. Mr. Shockley, place your appearance on.
On behalf of the people.
All right, today is the date scheduled for a preliminary examination. This is on one count of retail fraud, first degree. People prepared to proceed.
Yes, Alex.
All right, any preliminary matters?
Did you, pursuant to the court rule, confirm that the defendant still wishes to represent himself as this is a critical proceeding?
No, but do you still wish? Assume he did.
Yeah, it just has.
He's been
voluntary.
He's just been asking all this time. Would you still want to represent yourself? You've been telling us all this time. Do you want to represent yourself?
I've been wanting to represent myself.
Okay, so you want to proceed today by yourself without a lawyer, right?
Not before I let it be known that I still never received my full discovery.
Well, what haven't you received, sir?
I haven't had a chance to go over the videotape because one of the witnesses in the videotape that I know that when I was speaking to him and was saying, letting him know that, look, man.
Today's case takes us inside a Michigan courtroom where a man accused of retail fraud insists on defending himself against the system. No lawyer, no legal team, just him, his words, and a judge trying to keep the order. But here's where things take a turn. This defendant, Timothy Dansby, believes he's being silenced by the same legal process meant to protect him. As he argues for his right to discovery, we'll see tension build, confusion unfold, and a crash course in courtroom reality.
Put this stuff back on here because I'm choosing not to buy it here and I'm going someplace else. So it wasn't like I was trying to steal nothing when I told the guy this particular, I wanted to make sure that he's being available to be questioned.
I don't know who he's going to call. See, this isn't a trial. So this is just your probable cause hearing. So the prosecutor has a very low threshold burden of proof. He doesn't have to put on every witness, he said. He doesn't necessarily have to use the video. He might. And if you say the video means something else, that creates a question of fact that would go to trial for the trier fact to resolve. And of course, you get an opportunity to question about the video in depth at trial.
Also, I'd like to mention the fact that, you know what I'm saying, that it's been a delay because I don't know who these people have been coming up here. I've been telling the court that I've been wanting to represent myself.
Well, you've been representing yourself since the last time.
Well, at the county jail, they said without the court allowing them to know that I was representing myself, there was certain information I couldn't get. They would not give me. Like the Michigan court rules of evidence. You know what I'm saying? For part.
I've never heard of the court having to tell the jail you're representing yourself.
No,
I've never heard of that.
The new technology, they used to have a law library you could go. But now you do everything over the computer.
Okay.
You got to leave a request. In order for them to fulfill your request, they have certain criteria that you got to show ahead of time.
Well, sir, I don't know anything about what the jail's criteria is.
And also, I'd ask, for a standby lawyer.
But they don't do that.
Well, from my understanding,
this is where most self-represented defendants start to sink. Dansby wants to represent his story, but that passion clashes with courtroom procedure. The judge's patience is being tested, not because of attitude, but because every second wasted today can mean delays, paperwork, and another 30 days in county. Pro SE defendants often underestimate how structured hearings are. The court isn't there to hear emotions. It's there to assess facts. And right now, Dansby's frustration over discovery is clouding the very point of today's hearing, whether there's probable cause to move forward.
Okay, court.
No, I know there has to be a circuit court.
This is the state system.
There has been opportunity to have standby lawyer for instances where they could confer certain information that the prosecutor might not want to give to me because he might feel he's better than me or something. Because he feels that my constitution right.
Listen, Mr. Dansby. We can't keep. No, of course you got. That's not true. You have a right to represent yourself and you do have a right to get discovery. But what you can't do is come in here on the day of the hearing claiming that, oh, now you want to stand by counsel.
I said,
okay, but I'm telling you.
I'm just saying, well, from my
Well.
experience, it's always been, standby counsel been set aside.
I don't know what your experience is. I just know what Michigan and I don't know when you got,
Well, of information.
okay, sir.
And
The Michigan Indigent Defense Rules, they have a whole new program that's been started a few years ago. So we used to do standby counsel and anything like that. We used to do that all the time when the court was appointing. Now they have a whole system. They don't pay for that. They say if the defendant wants a lawyer, fine, but there's no quote standby lawyer in their view, so they don't pay for that. I didn't make that rule. The person,
I couldn't verify it if I wanted to without.
well, the person that,
Without the people in the jail who's running the law library information, able to send me the information that I need, because without them having, and for their quote.
okay, what
unquote,
information
their
do,
quote unquote.
sir, what information do you think you need just for a preliminary exam?
Your Honor, just
No, I said,
Here's the heart of the issue: discovery. In criminal law, discovery is a process of sharing evidence between prosecution and defense. Dansby believes he's being denied access to crucial footage that could clear his name. But technically, at this stage, the court doesn't owe him full discovery yet. The judge clarifies that standby counsel is not a guaranteed right under Michigan's indigent defense system. Translation: if you want a lawyer, you get one, but you can't have half a lawyer on standby for advice. And that rule, while frustrating, keeps the legal process uniform.
for Michigan Indigent Defense appointment.
So then you said it used to give standby counsel.
I said, we did before that system was created.
Well, I want all the chance to update on the system, y'all.
Okay, but that has nothing to do with this.
Court rules of evidence.
Your Honor, I'm gonna, just so I can expedite this, and to satisfy the defendant, at the circuit court level, the circuit court has the budget and the ability and the staff to appoint a standby counsel once he gets up there. And once we finish this hearing, he may be up there and he can make that request then, and I'm sure the circuit court will have no problem immediately assigning him an attorney to advise him as he represents himself. As far as the people are concerned, the court has been complied with. He's freely and voluntarily relinquished his right to an attorney. May I call my first
So the
witness?
court, so, yeah, I like to also state that I still haven't received my discovery, and my date was postponed because of some guy who said he was my attorney. I did an extra 30 days, the extra 30 days.
Well, if you keep this up,
That's my attorney.
you
Why
gonna,
wasn't my, why?
you're gonna be here another 30 days. Do you want me to adjourn this case again?
No, I don't want to talk. I'm really actually having dismissed.
No,
For the simple fact that.
we're not doing that.
Or ask for a personal bond, because I've been had my cases adjourned on other people's. That,
Sir, you the one that asked for new lawyers or no, or no lawyer.
ask for any new lawyer because I never accepted the first. I have never signed for an appointment of an attorney from the very beginning, even at.
Okay, sir. Well, we're gonna proceed with your preliminary examination without a lawyer. So you should be happy today that you don't have one. And then when you get to the circuit court, ask them to give you a lawyer. He just said they have a budget for that.
Ask them to give me my discovery.
What discovery don't you have?
This is the exact moment courtroom watchers love, when patience meets pressure. The judge has heard enough circular arguments. Dansby wants discovery, wants his case dismissed, and maybe a personal bond, all at once. What he's missing is how procedural hearings work. You can't fight the case, request release, and challenge evidence simultaneously in a probable cause hearing. The judge, meanwhile, walks a tightrope, balancing due process with courtroom control.
With all the preliminary examples.
Okay. Have a seat, sir, unless you want to stand up for the whole hearing. Okay, Mr. Shockley, are you ready?
I am ready.
Okay. Raise your right hand. Do solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth.
Yes, sir.
All right, thank you. Have a seat. And Mr. Shockley, whenever you're ready.
Yeah, sir, when you are ready, will you please state and spell your name for the record?
Yes, it's Robert Sammons. R would be ERT, last is SAMMONS.
Who is your employer?
Meyer,
What is your job title with Meyer?
Asset Protection Team Lead.
Asset Protection Team Lead?
Yes, sir.
And how long have you been employed in that capacity by Meyer?
Since January of 2025.
Did you receive any specialized training to have that title or that role?
Yes,
And what do you do? What kind of training?
So it's a multitude. So over years, Wicklander, certified, and then different courses in, asset protection and policy related, that kind of stuff.
Are those courses designed to help you detect retail frauds or patterns of retail frauds?
Yes.
Um, yeah, next question. Were you employed in that capacity on July 26, 2025, around five 5:30 p.m.?
Yes, sir.
Okay. And so, do you work at a specific Meijer store or multiple stores?
I'm assigned to.
Now, this is actually a fascinating moment. The narrator cites MCR 6.201A6, a real Michigan court rule that entitles defendants to inspect evidence used against them. Technically, Dansby should be allowed to view the tape before it's used. However, his failure to properly request it in writing leaves a loophole for the prosecution. It's a classic catch-22, a defendant demanding justice without fully understanding the procedural steps needed to claim.
To the one in Southfield.
Is that located at 28800 Telegraph Road,
Yes.
City of Southfield,
Yes.
County of Oakland?
Yes.
On that date, around that time, did you identify a retail theft in progress?
Yes.
And how did you identify that?
In this particular case, it was just, rapid selections of, similar merchandise.
What do you mean rapid selections?
So one of the indicators of theft is, grabbing merchandise without looking at price, or without appearing to look at price, size, that kind of thing.
And how did you see this occurring?
On the floor.
Were you physically on the floor or were you watching cameras?
Sorry, I was physically on the floor.
Did you follow this individual
I did.
as he was selecting items?
Correct.
Do you see that individual you were following presently in the courtroom?
I do.
Will you please point and identify an article of clothing he is wearing?
It's the, over to my left, and he's wearing like a blue, shirt with a white t-shirt.
Your Honor, may the record reflect the proper identification of the defendant?
Yes, so ordered.
Upon following this individual, did at one point he come to the point of sale?
He did.
Was that before, at any point did he try to walk out before coming to this point of sale?
No,
Did he have a cart or was he concealing these items on his person?
it was a carton.
Was that cart full?
Yes.
Upon him going to the point of sale, what did you, just so we put, you were at the point of sale when he got there.
I was, yes.
And what did you see him do at that point?
He went up to a, cashier, and myself and asked where the bathroom was.
Was that before or after the cash register?
That was, it's kind of at the same time. It's like at a, it's like a giant area where there's like self-checkouts.
Are these self-checkouts?
Yes.
Is there a long looping line to the self-checkout?
Correct.
Did he still have the cart with him?
He did. So he left the cart, actually.
Now enters the store's asset protection lead, essentially corporate security for major retailers like Meijer. These guys are trained like investigators. Sammons describes rapid selections, a common theft indicator when someone grabs items without checking sizes or prices. The key here? Intent. The prosecution must prove Dansby intended to steal, not just shop chaotically. But in cases like this, the witness's credibility is everything. If he sounds calm, methodical, and trained, the court is far more likely to lean toward the prosecution's narrative.
By me, and then he went to the restroom.
And what did he do? Did he come out of the restroom?
He did.
What did he do upon coming out of the restroom?
He grabbed a cart and proceeded towards the opposite side of the store, which would be the grocery side.
And what did he do upon getting to the grocery side?
He pushed the cart out, exiting the store without offering payment.
When you say he pushed the cart out, is there a double door vestibule to Meijer?
Yes.
Did he enter
what?
a double door vestibule?
Vegetable.
That's the whole.
Oh,
Not
vestibule.
vestibule. Yeah.
Okay, got it. Okay, go ahead.
Yes, so it's the, it's basically what it is. It's an opening with EAS towers, and then he pushed past those EAS towers.
What is the EAS tower?
Electronic article surveillance that detects the tags, that the merchandise protection tags. virtually, it's the thing that beeps when you pass it.
Did they beep?
None of these had tags, so no.
Okay. Did you, stop him at that point?
Yeah.
Did he say anything to you upon stopping him?
He said, I can't recall exactly what he said.
But he did say something?
He did.
Okay, and what did he do upon you confronting him?
He walked past me and then went out the doors going to on the directly side into the parking lot.
Did he abandon his car or did he try to take his car with him?
He abandoned it.
Did you retrieve his card?
I did.
Were you able to scan the items that were contained within the card?
Yes.
Upon scanning these items, was a receipt produced?
It was.
Yeah, then may I approach the witness?
Yes.
People pose exhibit 1. So I take a second look at what I just handed you. What is that?
It's a receipt from there.
And does it fairly accurately depict the items you scanned from the part?
Yes.
Has that receipt been edited in any way to your knowledge?
No.
People are going to admit people's exhibit 1.
This is the turning point, the moment the tape comes into play. Surveillance footage can make or break a case, and Dansby knows it. His objection is valid. He hasn't seen the video, and now it's being introduced publicly for the first time. What makes this powerful is the timing. The court's about to show the very footage that could determine whether he's an innocent shopper or a caught thief. The judge tries to compromise, allowing him to view it before it officially admits.
Show it to him. Okay, sir, that is People's Proposed Exhibit 1. Hello? Well, he's offering it. Is there an objection? Okay, no objection heard, admitted.
Commissioner, approach and publish.
Yes.
Thank you. Sir, does, monitor take camera?
We did.
And were those cameras working and operational on that day?
They were.
And did, upon him leaving the court, did you contact law enforcement? Did law enforcement come to your location?
They called him, like in the, they went towards 12 Mile, made a right. I'm sorry, I don't know if it's east or west, but made a right. And then they caught it right there. And then they came.
So, okay, so to answer my question, law enforcement did come to your location?
Yes.
Upon them coming to your location, did you show them video for the incident?
Yes.
Previously to you taking the stand, did I show you what's on the splash drive?
Yes.
Is what's on the splash drive the videos from my road that day?
Yes.
People were moved to Mesh People's Proposed Exhibit 2.
So, any objection?
People's Proposed Exhibit 2 is the camera footage from mine, correct?
Yes.
And that's the same footage we turned over to the police? Yes. People were moved to Mesh People's.
I object to the fact, John, that I haven't had a chance to go over, take previous to the examination. You know what I'm saying? I'd like to state for the record that being able to go there would be part of my discovery. And since the prosecutor said, I guess upon his word, I guess he's making precedence with that. You don't have to give.
But why don't we do this, sir? Let's play the video without admitting it so you can watch.
And there you have it, a courtroom showdown between frustration and procedure. Timothy Dansby's story highlights the risks of going solo in a system built on precision. One misstep in process can turn a defense into a disaster. Whether he's guilty or simply overwhelmed, the bigger lesson is clear. The courtroom doesn't bend for passion, only proof does. So what do you think? Was the judge too harsh, or was she just enforcing order? Let us know in the comments below.